Assalamu alaikum. My name is Mohammad Mudassir Alam Shah. My bearing ID is 199261364. Today my presentation topic is Shapun Kumar Jain versus Omita Goldar. Discuss fact marriage presumption of the lower appellate court being the final of as fact. On consideration of the evidence on record, come to a finding that marriage took place between the plaintiff and the defendant. This finding of fact with regard to marriage carried a valid presumption that a marriage in law under the Hindu system was solemnized upon observation of all the legal formalities, including Shatabdi and invocation before the sacred fire. This case was Shapun Kumar Jain was the petitioner versus Omita Goldar was the opposite party. Judgment this case June 25th, 2005. This case referred Amulya Chandra Modak petitioner versus Estate 55 DLR 160. Neela Jaman versus Giyasuddin Khan 34 DLR 221. Sharmin Hossain Ilyas Rupa versus Mizanur Rahman 2 BLC 509. Moinuddin versus Amina Khatun 42 DLR 483. Muhammad Shiazul Islam versus Helena Begum and others. Hasibur Rahman versus Shakila Begum and others respond 53 DLR. Utpal Kanti versus Mojnu Rani Dash 50 DLR. And lawyers involved Minal Kanti Vishwas, advocate for the petitioner, and Gomindo Chandra Tagore, advocate for the opposite party. In this case judgment, by these rules, the opposite party was called upon to show cause as to why the impeachment judgment and decree dated 12/6/2000 passed by the district judge Dhaka in the Family Appeal number 22 of 1993, reversing this date 10/5/1993, passed by the Assistant Judge, 4th Court of Family Court, Dhaka in Family Suite number 11 of 1987, should not be set aside or such other of further order or orders passed as to this court may seem fit and proper. These rules too arose out of judgment and decree passed by the learned district judge Dhaka, reasoning those of the family court judge and 4th court of the assistant judge Dhaka in family suite. Family suite was dismissed and appeal preferred by the plaintiff was allowed and the suit was decreed. The opposite party was plaintiff, family suit number 11 of 1987 in the 4th Court of Assistant Judge Dhaka against the present petitioner, praying for a decree for restitution of conjugal rights and for realization of maintenance cost, alleging inter alia that the plaintiff and defendant are involved in love affairs and they ultimately got married on 3/8/1983. They were marriages held at Dhakeshwar Mandir. It also alleged that the marriage was consummate and the plaintiff and the defendant, who used to live separately in hall and hostel, used to pass rights at different residential hostel in Dhaka for sexual intercourse. It is also asserted that the plaintiff and defendant became acquainted with each other for long before the marriage, and defendant was a student while the plaintiff was a service holder of a nurse of Dhaka Medical College. The plaintiff then preferred Family Appeal number 22 of 1993 before they learned district judge Dhaka. The appeal transferred the court of Nari o Shishu Daman Bishwas Adalat. The plaintiff Then the family appeal number 22, 1993, before the Land District Judge, Dhaka. The appeal was transferred to the court নারী ও শিশু নির্যাতন দমন বিশেষ আদালত, ঢাকা, under memo of Ministry of Law and Preliminary Affairs, but subsequently, in view of unreported decision on the High Court division taking the view that নারী শিশু নির্যাতন দমন বিশেষ আদালত has no jurisdiction to hear family appeals. The appeal before নারী শিশু নির্যাতন দমন বিশেষ আদালত, Dhaka, was retransferred to the Land District Judge for appeal. The Land District Judge allowed additional evidence to the procedure by the plaintiff, and also took the deposition of few minutes on behalf of the plaintiff and witness, and then by a judgment and decree dated 12/6/2000 held that the plaintiff has proved her case of marriage with the defendant, and accordingly allowed the appeal and decreed the suit, declaring that the marital tie between the plaintiff and the defendant subsist, and the defendant was directed to pay maintenance of the plaintiff at the rate of 80,000 per month. The defendant obtained a ruling Civil Revision number 4785 of 2000, and the plaintiff obtained a rule in Civil Revision number 1058 of 2001. Mr. Minal Kalantivicius, the learned advocate, appearing for the petitioner in Civil Revision on number 4785 of 2000, has placed both the judgment and decree of the trial court by which the suit was submitted, and suit was dismissed from the Minal Kalantivicius. Minal Kalantivicius then submit Mr. Minal Kalantivicius, the learned advocate, appearing for the petitioner in Civil Revision number 4785 of 2000, has placed both the judgment and decree of the trial court by which the suit was dismissed. Mr. Vishwas then submits that the lower affiliate court and committed on error of law in allowing additional evidence to be procedured before the appellate court, overlooking that family court ordinance does not provide for application of civil procedure code except in only section 10 and 11. Mr. Vishwas then submits that the plaintiff could not prove the two essential elements of Hindu marriage, namely invocation before the sacred fire and Shatabdi. In the absence of any proof of fulfillment of invocation before the sacred fire, Mr. Vishwas then submits that the plaintiff could not prove the two essential condition elements of Hindu marriage, namely invocation before the sacred fire and Shatabdi. In the absence of any proof of fulfillment of invocation before the sacred fire and Shatabdi, a Hindu marriage is not complete, and thus the plaintiff is not entitled to any relief in the suit. Lastly, a suit for restitution of conjugal rights is void. Mr. Govinda Chandra Thakur, the learned advocate, appearing for the plaintiff opposite party on the other hand, supports the decision of the lower appellate court and submits that the defendant did not appear in the suit to contest to the suit and did not file any written statement and thereby admitted the assertion. In the absence of any proof of fulfillment of invocation before the secret fire and short of the Hindu marriage is not complete, and thus the plaintiff is not entitled to any relief in the suit. Lastly, a suit for restitution of conjugal rights is void. Mr. Govind Chandra Thakur, the learned advocate appearing for the plaintiff opposite party, on the other hand, supports the decision of the lower appellate court and submits that the defense did not appear in the suit to contest the suit and did not file any written statement and thereby admit the assertion made by the plaintiff in the pleading, and thus on the admission of the defendant the suit would be decreed. I have considered the submission of the learned advocate for both parties and pursued the impeachment judgment and all other evidence on record from the Bijan Kumar Dar said the plaintiff shows that the plaintiff clearly made an assertion that marriage under Hindu law in terms of Vedic ceremonies was observed in Nakeshwari Mandir by a Purohit. The plaintiff, however, made an assertion that there was an exchange of garlands before the deity Kalimata, and such statement alone would not disqualify the marriage held in Nakeshwari Mandir by a Purohit upon observance of his all formalities as required under Hindu law. This finding of fact with regards to marriage carried a valid presumption that marriage in law under the Hindu system was solemn. The finding of fact with regards to marriage carried a valid presumption that a marriage in law under the Hindu system was solemnized upon observance of all legal formalities, including Shatabdi and invocation before the sacred fire. I have myself pursued the plaint and the evidence of Purohit who solemnized the marriage and stated in his evidence that there was Shatabdi at the time of marriage. Also, I am now called upon to consider whether additional evidence is permissible before the appellate court against the judgment, decree or order passed by the family court. The finding of fact of the final court of fact being based on assessment and consideration of evidence. I do not find any ground to disagree with such finding of fact. The learned advocate for the petitioner could not find out any misreading of evidence or non-consideration of evidence or misconstruction of evidence to permit this divisional court to disturb the finding of fact recorded by the final court of fact. This results the civil revision number 4785 of 2000 is discharged without any order as to cost. Civil revision number 1058 of 2001 is also discharged with the modification that the defendant shall pay an amount of 2,000 per month from the month of June 2005 by way of money order within the 10th of every English calendar month to the address of the plaintiff. As mentioned in the cause title of civil revision number 4785 of 2000, the plaintiff is further directed to notify the defendant if any change in her address takes place by a registered post, with acknowledgement due to so that the defendant may meet the monthly maintenance for every month. In the facts of the case, I do not make any order as to cost. The order of conditional stay as granted 10/1/2001 is hereby vacated. The learned advocate for the petitioner further submits that his client has duly paid the monthly amount of taka 8,000 up to the months of March 2005. In the result, Civil Revision number 4785 of 2000 is discharged without any order as to cost. Civil Revision number 1058 of 2001 is also discharged with the modification that the defendant shall pay an amount of taka 2000 per month from the month of June 2005 by way of money order within 10th of every English calendar month to the address of the plaintiff as mentioned in the cause title of Civil Revision number 4785 of 2000. The plaintiff is further directed to notify the defendant if any change in her address takes place by a registered post with acknowledgement due to, so that the defendant may remit the monthly maintenance for every month. And in the facts of the case, I do not make any order as to cost. The order of conditional stay as granted 10/1/2001 is hereby vacated. The learned advocate for the petitioner further submits that his client has duly paid the monthly amount of taka 800 up to the months of March 2005. Thank you, ma'am. Allah Hafiz.